Hello, everyone. The world stage has seen a whirlwind of activity recently, with significant shifts in global politics, economic policies being debated across continents, and social movements gaining momentum. Amidst all this, specific domestic issues within the United States continue to evolve, demanding our attention. Today we delve into a particularly pressing matter: the increasingly precarious situation for undocumented immigrants in certain parts of the country. We'll be examining which states are implementing stricter measures and what this means for the individuals and families affected. Stick around until the end, where we'll synthesize these developments and offer some concluding thoughts on this complex issue. It's often said that America is the land of opportunity, a beacon for those seeking a better life. But what happens when that perceived opportunity encounters the hard reality of state lines and differing legal landscapes? Imagine this scenario. You are pulled over for a minor traffic infraction, perhaps a broken taillight. What seems like a routine stop escalates rapidly. Before you know it, the questions shift from your driving record to your immigration status. And suddenly, you're facing the daunting prospect of deportation, separation from your family, and the unraveling of the life you've built. Does this sound extreme? Like something out of a cautionary tale? Unfortunately, for many undocumented individuals living in specific states across the U.S., this is an increasingly tangible and terrifying reality. It's happening right now, turning everyday activities into high-stakes risks. The state where you reside can dramatically alter your life, marking the difference between relative safety and constant surveillance, between community integration and the ever-present fear of detention and removal. Why is there such a stark divergence? We're witnessing some states aggressively doubling down on immigration crackdowns, enacting stringent laws and empowering local authorities to act as de facto immigration agents. Concurrently, other states remain comparatively silent or even adopt more welcoming stances, creating a patchwork of policies that leaves millions navigating a minefield of uncertainty. What fuels this legislative push in certain regions? Why are new laws emerging that often feel less like regulations and more like thinly veiled warnings, sending chilling messages to immigrant communities? Buckle up, because the journey through this landscape is fraught with peril. If you are undocumented, residing in certain states might mean living under the shadow of constant threat. Today, we're identifying 10 states that, due to their current laws and enforcement practices, might arguably be the most dangerous places for undocumented immigrants to call home. Understanding this reality is crucial, not just for those directly affected, but for anyone concerned with justice, human rights, and the very fabric of American society. Before we proceed, if you find this content informative and important, please consider subscribing to our channel and hitting the like button. Your support is invaluable in helping us bring these critical issues to light and continue our work. And let us know in the comments where you're watching from. We appreciate knowing our audience. Let's begin our examination with number 10, Texas. The Lone Star State, vast and economically powerful, presents a complex picture for immigrants. You might think that having lived there for years, establishing roots, contributing to the community, would offer some measure of security. Think again. Texas has become a focal point of intensified immigration enforcement, blurring the lines between state and federal authority. In this state, even the most mundane activities, like a simple walk to the grocery store or driving to work, can transform into a moment of profound vulnerability. If you lack the required documentation, an encounter with law enforcement for any reason, however minor, could lead you down a path toward detention and deportation proceedings. The fear isn't abstract, it's woven into the daily lives of many. We're specifically talking about Texas because its approach to immigration enforcement has shifted dramatically towards a more aggressive stance. The state legislature has taken significant steps, culminating in the passage of Senate Bill 4 in 2023. This landmark legislation represents a major expansion of state power in immigration matters. SB4 grants state and local law enforcement officers the authority to arrest and initiate deportation procedures against individuals suspected of being undocumented. This is a significant departure from the traditional model where immigration enforcement primarily falls under federal jurisdiction, specifically Immigration and Customs Enforcement, ICE. Now, Local police officers, whose primary duties typically involve community safety and enforcing state and local laws, are empowered, and in some interpretations, potentially mandated, to act as immigration agents. The implications are far-reaching. A routine traffic stop can quickly escalate into an immigration inquiry. An officer responding to a minor disturbance might inquire about legal status. This creates an environment where undocumented residents may fear interacting with police even when they are victims of crime or need assistance, potentially undermining public safety for everyone. Furthermore, SB4 introduces harsh penalties. If that wasn't enough to instill fear, the law also stipulates that re-entering the state after being deported can lead to felony charges, carrying potential prison sentences of up to 20 years. Imagine facing 2 decades behind bars simply for returning to the place you considered home, perhaps to reunite with family. Sounds wild, doesn't it? This severity underscores the state's determination to control its borders and regulate the presence of undocumented individuals within its territory. It's crucial to understand that this isn't a federal mandate. It's Texas taking matters into its own hands, asserting state authority in an area traditionally governed by federal law. This has inevitably led to legal challenges. Lawsuits are flying, arguing that SB4 infringes on federal authority over immigration and violates constitutional rights. Civil rights groups and the federal government are contesting the law's validity in court. However, while the legal battles unfold, the fear generated by SB4 is already palpable within immigrant communities across Texas. The uncertainty and the potential for severe consequences cast a long shadow. Could your next traffic stop, a minor interaction you wouldn't normally think twice about, turn into a one-way ticket out of the country, away from your life, your job, your family? If you're undocumented in Texas, the chilling answer under the current legal climate might very well be yes. And the consequences, as outlined by the law, are absolutely brutal, signifying a harsh reality for many residents of the state. Make sure to watch this video until the end, as we'll be providing concluding thoughts and summarizing the key takeaways from this examination of state immigration policies. Moving just one state over from Texas, we arrive at number 9, Oklahoma. If you thought the situation in Texas was alarming, wait until you hear about the developments in the Sooner State. Oklahoma is demonstrating that the trend of states enacting their own stringent immigration measures is spreading, setting its own traps for the undocumented community, and these measures are having a tangible impact. You might think things couldn't get worse than facing potential deportation after a traffic stop, but Oklahoma's approach adds another layer of severity and immediacy. Following closely on the heels of Texas's legislation, Oklahoma lawmakers took decisive action in 2024. They passed House Bill 4156, a bill that mirrors some aspects of Texas's SB4, but introduces its own unique and harsh provisions. This bill makes it a specific state crime, termed impermissible occupation, to be present in Oklahoma without legal federal authorization. This isn't just about deportation anymore. It's about criminalizing the very presence of undocumented individuals within the state's borders. The penalties are severe. A first offense under this law is classified as a misdemeanor, punishable by up to 1 year in county jail and/or a fine of up to $500. However, the consequences don't end there. Upon conviction, individuals are ordered to leave the state within 72 hours of their release. Failure to comply with this order constitutes a subsequent offense. A second offense escalates significantly, becoming a felony punishable by up to 2 years in state prison and/or a fine of up to $1,000, followed again by the 72-hour exit mandate. This rapid timeline for departure adds immense pressure and disruption to individuals' lives, offering little time to arrange affairs, contact family, or seek legal counsel. That's not just harsh. It's a calculated measure designed to make continued presence in the state untenable for those without documentation. And what if you're pulled over for something as simple as a busted headlight? In Oklahoma, under HB 4156, that could indeed be enough to trigger this cascade of consequences. The law empowers state and local law enforcement officers to inquire about immigration status during lawful stops or arrests if they have probable cause to believe the individual is in the country illegally. This broad discretion means minor infractions can quickly lead to immigration enforcement actions. You'd be shocked how rapidly someone can transition from a roadside encounter to facing jail time and mandated expulsion from the state. The law explicitly states that local police must enforce these provisions, effectively turning everyday officers into immigration agents, similar to the concerns raised in Texas. This mandatory enforcement aspect removes discretion and potentially increases the likelihood of profiling and arrests based on perceived immigration status. Sound extreme? It absolutely is. This state-level criminalization of undocumented presence represents a significant overreach into federal immigration authority and raises serious constitutional questions. And if you think no one is actually getting caught in this web, think again. Even before the law officially took effect, reports indicated that state authorities were already preparing for its implementation, and in some cases, making arrests based on related suspicions. The state has made dozens of arrests linked to this type of enforcement posture, and it appears this is just the beginning. The climate of fear is intensifying as communities grapple with the reality that their neighbors, colleagues, and even family members could be arrested and forced to leave the state on short notice, simply for lacking the correct papers. Could your next traffic stop morph into a scenario involving jail time and a forced exit from the state within 3 days? For undocumented individuals in Oklahoma, the passage of HB 4156 makes this a terrifyingly real possibility. The consequences are not just punitive, they are designed to be disruptive and life-altering, making Oklahoma a profoundly dangerous place for anyone without federal authorization. Let's cross state lines again and head north to number 8. Iowa. The situation here demonstrates how quickly these stringent immigration enforcement models can replicate and adapt across the country. Iowa's recent actions show a state seemingly determined to follow the path laid out by Texas and Oklahoma, creating an environment of heightened risk for undocumented immigrants. It might start off looking calm, picturesque small towns, seemingly quiet roads, and perhaps friendly faces greet you. But don't let the surface tranquility fool you. Beneath the calm, Iowa is quietly transforming into one of the harshest states for undocumented individuals, implementing laws that echo the punitive measures seen elsewhere. This place is methodically turning into a legal minefield, where a wrong step can have devastating consequences. We're talking specifically about Iowa, a state that, inspired by Texas's controversial Senate Bill 4, recently decided to take justice into its own hands regarding immigration enforcement. In early 2024, the Iowa legislature passed Senate File 2340, a bill that closely mirrors the Texas law and effectively makes it illegal under state law to be undocumented within Iowa's borders if the individual has previously been deported or denied entry to the U.S. You'd be shocked how swiftly this legislation came together, seemingly fast-tracked through the legislative process, signed, sealed, and ready for enforcement starting July 1, 2024. This law empowers state and local law enforcement, including university police, to arrest individuals suspected of violating this new state statute. The penalties are significant and depend on the circumstances of the individual's prior removal or denial of entry. Depending on the underlying federal immigration violations, an arrest under SF 2340 could lead to either an aggravated misdemeanor or a felony charge at the state level. An aggravated misdemeanor carries a potential sentence of up to 2 years in prison, while a felony conviction could result in up to 5 years imprisonment. And here's the kicker, amplifying the severity. Even if you're not committing any other crime at the time of the encounter, simply being undocumented under the specific conditions outlined in the law, having a prior deportation or denial of entry, is enough to trigger an arrest and potential jail time under state law. This means routine interactions can become perilous. The law allows local officers to question and potentially detain anyone they suspect falls under this category during lawful stops or interactions. Sound vague? That's precisely the point, according to critics, who argue it opens the door to racial profiling and pretextual stops. A minor traffic violation, a routine ID check requested for another reason, or even hypothetically, walking through a neighborhood deemed suspicious by an officer could spiral into a full-blown legal nightmare under this new Iowa law. But guess what? It gets even worse, particularly concerning due process. Once arrested under SF 2340, the law allows a judge to order the individual deported, before they are even convicted of the state crime. While the order can be stayed pending the outcome of the criminal case, the potential for rapid removal based on suspicion alone is deeply concerning to immigrant rights advocates. And this isn't just a theoretical scare tactic. Authorities in Iowa have indicated their readiness to enforce the law vigorously once it takes effect. Given the precedent set by similar laws in other states, the expectation is that arrests and deportations will follow swiftly. Families are already grappling with the potential repercussions, fearing separation and the disruption of their lives. Children, many of whom are U.S. citizens, face the trauma of potentially losing parents to detention or deportation triggered by state-level enforcement. Families are being torn apart, not by federal action, but by state laws copying controversial measures from elsewhere. The speed with which this occurred, rushed passage, quick signing, suggests a determined effort to crack down. And for those thinking, it can't happen to me, consider this. What if one interaction, one check based on unclear suspicion, changes everything? Iowa isn't just following Texas's footsteps. It's doing so with potentially less media scrutiny and organized resistance than seen in larger border states. That lack of widespread attention arguably makes it even more dangerous. The scariest laws are often the quiet ones, the ones people don't notice until it's too late to stop them. And in Iowa, that silence surrounding SF2340 is becoming deadly for undocumented communities living in fear of July 1st. Now, let's journey south to a state synonymous with sunshine and beaches, but which has recently gained notoriety for enacting some of the most sweeping and harsh immigration laws in the United States. Number 7. Florida. While often portrayed as a vacation paradise, the reality for undocumented immigrants in the Sunshine State has become increasingly grim, transforming the landscape into a place of significant risk and fear. The paradise effectively ends fast if you lack documentation. Welcome to Florida, where recent legislative actions have ramped up enforcement and penalties, impacting nearly every facet of life for the undocumented population. In March 2023, this state significantly escalated its stance with the signing of Senate Bill 1718 by Governor Ron DeSantis. This comprehensive legislation implemented a raft of new measures that have sent shockwaves through immigrant communities and drawn national attention. The law touches upon employment, transportation, healthcare, and identification, creating a multi-pronged approach to deterring undocumented immigration and increasing enforcement. One of the most impactful provisions strengthens penalties for transporting undocumented individuals into the state, making it a felony. It also invalidates out-of-state driver's licenses issued to undocumented immigrants, increases penalties for using false identification related to employment, and mandates employers with 25 or more employees use the E-Verify system to check the work eligibility of new hires. But here's what's particularly wild and concerning. Driving without a valid license in Florida, already an offense, can now lead to longer potential jail time specifically because of one's immigration status under certain interpretations and applications of related laws and enhanced penalty considerations. The intersection of traffic laws and immigration status becomes a dangerous trap. A simple traffic stop can expose an individual's lack of documentation, leading not just to traffic citations but potentially to detention and deportation, especially with increased cooperation between local law enforcement and ICE. It's not just the laws themselves, it's the system reinforcing them. Florida has consistently ranked among the states with the highest number of deportations in the country. In the last year alone, thousands of families have been separated due to these enforcement priorities. ICE raids, often conducted in collaboration with local authorities, have become more frequent, more aggressive, and increasingly public, further fueling anxiety within communities. The reach of SB1718 extends even into traditionally safe spaces. Hospitals are now required to ask patients about their immigration status upon admission. While the data collected is purportedly for tracking healthcare costs and not direct enforcement, this requirement has understandably deterred many undocumented individuals from seeking necessary medical care, fearing that their information could somehow end up in the hands of immigration authorities. Yes, you heard that right. Simply getting medical help could become a risk, potentially leading people to forego essential treatment due to fear. And what if you're a child of undocumented parents? The climate of fear extends into schools as well. Although the law doesn't mandate schools report undocumented students, which would violate federal law, the broader enforcement environment has created significant anxiety. Anecdotal reports suggest some schools, perhaps misunderstanding the law or acting out of an abundance of caution, have implemented policies or practices that scrutinize the status of guardians during enrollment, leading some parents to hesitate in sending their children to school. The fear is real, pervasive, and creeping into every corner of life, from the workplace, where E-Verify looms large, to the doctor's office, and even the school gates. The result? Communities are shrinking as families flee the state. Reports emerged shortly after SB1718's passage of families packing up overnight, abandoning homes and jobs to move to nearby states perceived as safer. Some are even considering leaving the U.S. altogether. You'd be shocked to see how quickly the atmosphere changed. Just 5 years ago, many parts of Florida were considered relatively safe havens compared to stricter states. Today, they are increasingly viewed as trap zones. And guess what? It's likely only going to get tougher. Lawmakers in Florida have shown a continued appetite for stricter measures, pushing for even more rigorous enforcement, increased funding for local cooperation with ICE, and potentially mandatory immigration checks in more sectors. So ask yourself this: what happens when your doctor, your child's teacher, or your boss becomes a potential threat, required by law to inquire about or verify status? What happens when the basic necessities of normal life, working, seeking health care, educating your children, become fraught with the risk of deportation? In Florida, this isn't a hypothetical scenario. It's the lived reality for hundreds of thousands, and the clock is ticking as enforcement continues to ramp up. Let's turn our attention now to number 6, Georgia. Often associated with Southern charm and peaches, Georgia has a long and complex history with immigration enforcement, marked by periods of intense crackdowns, followed by legal challenges and shifts in policy. What if every move you made, every interaction, felt like a countdown, not because you've done something wrong, but simply because you exist without the right papers? That's the chilling reality that many undocumented immigrants face in Georgia, a state where being undocumented isn't just difficult, it's a daily gamble with potentially life-altering stakes. In 2024, Georgia intensified its already tough stance, aligning itself with the trend of states empowering local law enforcement to act aggressively in immigration matters. This new wave of laws builds upon a foundation laid years ago, solidifying Georgia's place as a high-risk state. Central to Georgia's enforcement strategy is its extensive participation in the 287G program. This federal program allows the Department of Homeland Security, DHS, to delegate immigration enforcement authority to state and local law enforcement agencies. Georgia has historically been one of the most active participants in this program. In fact, the state once ranked among the top 5 in the country for the number of 287G agreements in place. This program essentially gives local law enforcement officers, sheriff's deputies in participating counties, the power to act as immigration officers, questioning individuals about their status, initiating detention holds, and facilitating transfers to ICE custody. That means you don't need to commit a serious crime to attract immigration enforcement attention. Under 287G agreements, even minor interactions with local police in participating jurisdictions, like a traffic stop or a response to a noise complaint, can lead to an immigration status check if an officer claims to have suspicion. You just need to look suspicious in the eyes of an officer trained and authorized under this program. You'd be shocked at how quickly someone's life can unravel from such an encounter. Furthermore, Georgia is home to the Stewart Detention Center, one of the largest immigrant detention facilities in the United States. Located in a remote part of the state, critics often refer to it as a black hole due to its isolation, limited access for legal counsel, and numerous reports alleging inadequate medical care and harsh conditions. Once an individual is transferred to Stewart, navigating the complex immigration system and securing release becomes exceedingly difficult. The sheer scale and remoteness of the facility contribute to the fear within immigrant communities. For those living in rural areas of Georgia, Far from major cities and established immigrant support networks, the fear is constant and amplified. There are often no big city protections, fewer legal aid resources readily available, and a greater reliance on local law enforcement who may be actively participating in programs like 287G. It can feel like navigating a landscape of silence and survival, where help is scarce and the threat of enforcement looms large. And it's not just direct enforcement actions. Georgia's legislative environment has also targeted those who might assist undocumented immigrants. While specific new laws mirroring the transportation or harboring felonies seen in Florida or Texas might be debated or evolve, the underlying principle of discouraging support for the undocumented is present. Bills have been introduced or considered that could penalize landlords who rent to undocumented tenants or employers who hire them without rigorous verification, often pushing for mandatory e-verify use beyond federal requirements. Imagine the chilling effect, fearing repercussions simply for offering shelter or work to someone in need. Even children aren't entirely spared the indirect consequences. While schools cannot legally deny enrollment based on status, the climate of fear created by aggressive enforcement policies, coupled with potential, though often legally dubious, scrutiny of parental documentation during registration in some areas, leads some undocumented parents to fear sending their kids to school, potentially impacting their education and well-being. Why? Because the data collected, even for seemingly benign administrative purposes, could theoretically be shared or accessed by other state agencies involved in enforcement, increasing vulnerability. One wrong document submitted, one school administrator asking too many questions under perceived pressure, and families could be split apart. So ask yourself this: what kind of state leverages its local law enforcement as immigration agents through programs like 287G? What kind of place operates massive remote detention centers known for difficult conditions? What kind of system potentially penalizes citizens for helping neighbors or family members? In Georgia, the answer is unfolding right outside your front door, making it a state where the promise of Southern hospitality clashes harshly with the reality of immigration enforcement. Let's delve into number 5. Alabama. If you want to talk about states going all in on immigration enforcement, you absolutely need to hear about Alabama's history and its current climate. This state has a track record of enacting some of the most notoriously aggressive anti-immigration legislation in the nation, creating an environment where immigration enforcement isn't just strict, it feels relentless and pervasive. Long before some of the more recent state-level crackdowns gained national attention, Alabama made headlines with its infamous House Bill 56, passed back in 2011. This law was widely considered at the time the toughest state-level immigration law in the United States. Its provisions were sweeping and draconian. HB 56 required police to check the immigration status of anyone they stopped, detained, or arrested if they had reasonable suspicion the person was undocumented. It mandated schools verify the immigration status of enrolling students, a provision quickly challenged and blocked by courts. It criminalized giving an undocumented immigrant a ride, renting property to them, or knowingly employing them. It even prohibited undocumented immigrants from entering into basic contracts, essentially attempting to make everyday life impossible. The immediate impact was devastating. Reports flooded in of families fleeing the state overnight, workers abandoning agricultural fields leaving crops to rot, construction projects stalling, and widespread fear paralyzing communities. Children were pulled from school by terrified parents. The economic consequences were also significant, with industries reliant on immigrant labor facing severe shortages. Although federal courts eventually struck down or blocked the most egregious parts of HB 56, finding them unconstitutional or preempted by federal law, the law's legacy lingers, and the state's underlying enforcement posture remains aggressive. And now, in the current climate of 2024 heading into 2025, Alabama is showing signs of potentially revisiting or reinforcing its tough stance, emboldened by actions in neighboring states. While major new legislation mirroring the scope of HB 56 hasn't necessarily passed this year, the existing legal framework and the political will for enforcement remain strong. For instance, Alabama continues to push for rigorous enforcement of employment verification laws, potentially expanding mandates for systems like E-Verify, even for smaller businesses beyond federal requirements. One recent bill discussed or passed might force employers to verify immigration status more thoroughly, not just at hiring, but potentially during random audits or contract renewals, keeping employees in a constant state of uncertainty. Imagine having held a job for years, contributing taxes, and suddenly facing termination and potential reporting due to a renewed verification push. The state also continues to encourage or facilitate cooperation between local law enforcement and federal immigration agencies like ICE, even without a statewide 287G mandate across all counties. Informal partnerships and information sharing mean that local jails often function as pipelines to ICE detention. Even a petty misdemeanor, like a minor traffic offense resulting in arrest, can get you flagged, held on an ICE detainer, and handed over for deportation proceedings. In fact, analysis of past data, even after parts of HB 56 were blocked, showed a significant percentage of immigration arrests in Alabama originated from local law enforcement interactions, often for minor violations. Let that sink in. People facing deportation potentially triggered by something as minor as driving without a license or an expired tag. Furthermore, the chilling effect extends to essential services. Although the requirement for hospitals to check status might not be currently enforced as written in the original HB 56 due to legal challenges, the memory and the general climate can still deter undocumented individuals from seeking necessary medical care, fearing any interaction with official institutions. Imagine needing urgent medical attention, but hesitating because your name might enter a system accessible to immigration enforcement. And schools? While the mandate to check student status was blocked, the fear among undocumented parents persists. The aggressive enforcement culture can lead parents to worry about interactions with school officials, potentially impacting enrollment or participation in school activities, fearing that any misstep could lead to devastating consequences for their family. And guess what? That's exactly the outcome some hardline politicians seem to desire. A strategy of attrition through enforcement, making life so difficult and fear-inducing that undocumented immigrants self-deport. Alabama isn't interested in welcoming immigrants. The political winds often blow towards driving them out. The state is reviving aspects of its tough approach, perhaps through revised, legally refined means. Landlords might face renewed scrutiny or encouragement to report undocumented tenants. Community members might hesitate to offer rides or assistance for fear of violating potentially revived harboring interpretations. It's a climate where your school, your job, your landlord, and the local cop could all feel like part of the same trap. Where do you run when the system seems designed to push you out? In Alabama, the system is indeed designed to make you choose between living in the shadows or leaving. And either way, for many undocumented families, it feels like losing. Before we move forward, take a quick second to subscribe if you haven't already. Your support helps us keep exposing the harsh truths that many platforms shy away from. That single click helps us remain independent and ensures you stay informed. Now let's head to the coast, to number 1, South Carolina. Known for its sunshine, beautiful beaches, and historic charm, South Carolina might seem like an inviting destination, especially if you're just looking at the tourism brochures. Maybe on the postcards, it looks idyllic. But for undocumented immigrants, the reality paints a very different picture. South Carolina feels less like a welcoming southern state and more like a brewing storm, steadily implementing policies that increase risk and vulnerability. This year, South Carolina lawmakers have followed the trend, passing some of the boldest anti-immigration legislation we've seen recently, creating a climate of fear that permeates daily life. This new bill doesn't just target undocumented individuals directly. It casts a wide net, aiming squarely at anyone who might offer them assistance. This includes landlords who provide housing, employers who offer jobs, and even family members trying to help their loved ones. You heard that correctly. In South Carolina, under the newest legislation, if you're caught knowingly housing someone without papers, or even transporting them, perhaps giving a relative a ride to work or the doctor, you could face serious penalties yourself, potentially including jail time or substantial fines depending on the specifics of the final law and its interpretation. Think about the implications. A basic act of kindness or family support could be criminalized. And guess what? They are serious about enforcing it. Local police are being further empowered, sometimes through cross-training initiatives with immigration agents or specific state mandates, to inquire about immigration status during routine stops or interactions. The threshold for suspicion can be low and subjective, meaning racial profiling is a significant concern. And there's little room for sanctuary. South Carolina has some of the strictest anti-sanctuary laws in the country. This means that cities and counties are generally prohibited from enacting policies that would limit cooperation with federal immigration enforcement. Localities cannot choose to opt out or create safer zones. They are often mandated to comply with ICE detainers and facilitate deportations. There's essentially no wiggle room, no local protection from the state's aggressive stance. Even school districts that might want to protect their undocumented students and families face immense pressure. While they can't legally deny education based on status, state-level policies or threats of funding cuts can compel them to scrutinize documentation during enrollment or report behavioral flags, however vaguely defined, to authorities, effectively turning schools into arms of the surveillance state. Data sharing between state agencies is also a growing concern, meaning information provided for one purpose, like getting a driver's license if eligible, or accessing state benefits for eligible citizen children, could potentially end up flagging a family for immigration enforcement. One wrong move, one piece of information shared in the wrong place, and your entire life could be upended overnight. It doesn't stop there. The state is actively encouraging employers to use systems like E-Verify, often going beyond federal requirements to mandate its use for more businesses, including smaller ones or subcontractors. This makes finding legitimate work incredibly difficult and pushes many undocumented workers further into the underground economy, where they are more vulnerable to exploitation and lack basic labor protections. Imagine losing your job, your only source of income, simply because of a verification check, even if you've been a reliable employee for years. South Carolina might smile for the tourists, showcasing its beaches and historic sites, but beneath that veneer of Southern charm, it has constructed a formidable and dangerous environment for undocumented immigrants. It's become one of the most hazardous places in the country if you lack documentation. One wrong turn, one minor infraction, and the system is designed to catch you, detain you, and potentially deport you, while also penalizing those who try to help. The entire ecosystem, from landlords and employers to potentially even schools and healthcare providers, depending on specific regulations, is being pressured to participate in this enforcement web. It's a stark reminder that the welcome mat is often pulled back abruptly depending on your legal status. So, we've journeyed through 10 states where the landscape for undocumented immigrants has become particularly treacherous: Texas, Oklahoma, Iowa, Florida, Georgia, Alabama, South Carolina, Arizona, Tennessee, and Louisiana. Each state, while unique in its specific legislative approach, contributes to a broader pattern of increasing state-level control and criminalization of immigration status. What conclusions can we draw from this? Firstly, the traditional notion of immigration enforcement being solely a federal responsibility is eroding rapidly. States are increasingly taking matters into their own hands, often creating laws that conflict with or go beyond federal statutes, leading to a confusing and dangerous patchwork quilt of regulations across the country. Secondly, these state laws often have a profound chilling effect that extends far beyond their direct enforcement. The fear of encountering law enforcement, even for minor reasons, deters undocumented individuals from reporting crimes, seeking medical help, or fully participating in their children's education. This undermines public safety, public health, and community cohesion for everyone. Thirdly, the focus often shifts from targeting serious criminal activity to targeting the mere presence of undocumented individuals, sometimes triggered by minor infractions like traffic violations. This raises serious questions about proportionality, due process, and the potential for racial profiling. Fourthly, many of these laws actively target not only the undocumented themselves, but also anyone who might assist them: landlords, employers, community organizations, even family members, creating a climate of suspicion and potentially criminalizing acts of basic human decency. Finally, the human cost is immense. Families are being separated. Communities are living in constant fear. Individuals are losing their livelihoods. And the very fabric of trust between immigrant communities and public institutions is being shredded. The land of opportunity narrative rings hollow when basic survival becomes a daily struggle against state-sanctioned surveillance and potential expulsion. These laws, often passed under the guise of public safety or border security, frequently result in significant economic disruption, social division, and profound human suffering. It's a complex issue with no easy answers, but understanding the reality on the ground in these states is the first step toward a more informed and humane discussion about immigration policy in America. Thank you for joining us today on this critical exploration. If you found this video insightful, please give it a thumbs up and subscribe to our channel for more in-depth analysis of the events shaping our world. We rely on your support to continue this work. Let us know in the comments section where you're tuning in from. We value connecting with our viewers. Remember, staying informed is more important than ever. See you in the next one.